Hello, this is Rosemary Zapor from the Lakewood Legal Center. I'm here today to discuss with you online wills. You know, as a lawyer, I'm paid to discuss with my clients the unexpected events in life. In other words, the what-ifs that can affect your estate planning. When I give seminars, there's always a person who wants to know why they should not use a form on the internet to write their will. Well, while an off-the-shelf will may seem very attractive because of the price, it can be a risky approach. If errors are made or if the strict witnessing rules are not followed correctly, the document could be declared invalid by a court. The implications of that can be serious. Not only do you risk leaving your family with a financial and emotional mess, but your legacy could be eaten away by legal bills or unnecessary taxes. Perhaps a few examples will explain the problem in more detail. These are actual cases from my office and others. The actual names are not used in order to protect confidentiality. Example number 1. Martha used an online service to write her will. At the time, she still had a mortgage on her home. Thinking that she would protect her home for her 3 children, she left all of her financial accounts to the bank by naming them as the residuary beneficiaries, but left the home to only one of her children. Martha paid off her home but never changed her will, and in fact had no further accounts with the bank. When Martha died, one child received the home, but the other 2 children received nothing. Martha had disinherited her children without intending to do it. Example number 2. Jerome set up a trust to protect himself and his family from probate. Jerome named himself as the trustee of the trust. This is common. Jerome also owned mineral rights to oil leases and set up an LLC, again through an internet source, that put the trust as the only managing partner of the LLC. The LLC and the trust had no provision for succession planning, which means that when Jerome died, both the trust and the LLC were left with no one to handle the business and no provision for what happens to the royalties after Jerome passed away. It all had to go to court, which is not what Jerome intended. Example number 3. Lisa is divorced from her husband, who is an alcoholic and physically abusive. They had 2 children together, both of whom are less than 10 years old. Lisa was short of money and decided to do a will, naming her mother as the guardian of her children in the event of her death, but no successor guardian. Lisa and her mother were in a car accident in which Lisa was killed. Her mother was severely injured such that she will be in rehabilitation for months. Lisa's ex-husband went to court and gained custody of the children based upon his being their parent and the laws in his state that gave a priority to the parent as the guardian. Other mistakes are often made while doing a form will, like naming an executor that has no financial or legal knowledge. This can lead to taxes and other legal problems. Leaving a bequest to a pet. Legally, you have to leave the bequest to an appointed caregiver. Putting conditions on payouts to an heir that are difficult or impossible to enforce, like, my son will inherit $10,000 only if he never drinks beer. I think it's obvious how you can't enforce a provision like that. Making unusual end-of-life decisions, or that puts your living will information into the will. If you want to be sure that your religious convictions regarding health care are followed, the will is not the place to do this. Neglecting to coordinate beneficiary designations where, for example, the will and the insurance policy designations contradict each other. Perhaps in a will you want to leave the beneficiaries as your children, whereas in one case in our office, the insurance policy designated the estate as the beneficiary. That means we had to open probate. Leaving funeral instructions in a will, since the document will most likely not be read until after the funeral has taken place. Leaving inexact or ambiguous instructions dealing with blended families. To my children. Do you want to include your stepchildren, your adopted children, children you are raising but are not your biological children? Neglecting to mention small items in the will, which, though of small financial value, are meaningful to loved ones and can cause family contention. So if you want to save money, don't use a form will. Have your will reviewed by a competent attorney. This is Rosemary Zapor, Lakewood Legal Center, 303-881-6354. Thank you.